उनका स्वागत करें. Let's welcome Honorable Justice J.K. Sikri, former Judge, Supreme Court of India. Now I will request Advocate, Mediator, and Joint Secretary Samadhan, Mr. Shyam Sharma, to come on stage, and welcome Mr. Anil Javier, Chairman, Asia Pacific Center for Arbitration and Mediation, by presenting him a plant. Shyam Sharma ji, please. Or Kartal Dhwani, huge round of applause for Mr. Anil Javier and all the panelists and moderators in this session, ladies and gentlemen. Welcome all of them. Our first moderator, the Judge, Delhi High Court, Honorable Mr. Justice Sudhir Kumar Jain, who is also a member of Overseeing Committee, Samadhan. I will introduce the moderators first, and they will be introducing the panelists later on. Justice Jain has joined the Delhi Judicial Services in 1992 and was promoted to the Delhi Higher Judicial Service in 2003. He was elevated as Permanent Judge of Delhi High Court on 28th February 2022. He is a trained mediator and trainer for the mediators. He has conducted more than 100 mediation training programs throughout India for judicial officers, advocates, and law students. He has spoken as an expert at various regional, national, and international conferences on mediation. He is also an accredited mediator by the International Mediation Institute, Holland. Our second moderator in this session is Senior Advocate Shri J.P. Singh Sahab. Mr. Singh is a well-known civil, commercial, and arbitration lawyer and an accomplished mediator. He has been founder organizing secretary of Samadhan, Delhi High Court Mediation and Conciliation Center. He is also Secretary General of Madhyam, an organization that aims at excellence in the development of law and resolution of conflict through alternative mechanisms. Mr. Singh received his basic training in mediation in India and his advanced training in different universities and institutes in USA. He has been appointed an observer by the Mediation and Conciliation Project Committee of Honorable Supreme Court of India for observing the training of the trained mediators. He has also been a member of a panel constituted by the Supreme Court of India for recommending legislation on mediation. He was awarded Lawyers of India Award by Bar Association of India in 2022. So once again, we welcome all the dignitaries on the dais. And with this introduction, ladies and gentlemen, I will request Honorable Mr. Justice Sudhir Kumar Jain to initiate the proceedings of this session. This is the last session, and this is about preparing for a mediation law in India. Over to you, sir.
Good afternoon to all of you. I am very well conscious of the fact this is the last session of this program, but I hope you will enjoy and learn from this session also. I take the opportunity as well as honor to introduce Honorable Mr. Justice Sanjeev Khanna and Honorable Mr. Justice A.K. Sikri. Justice Sanjeev Khanna was enrolled as an advocate with Bar Council of Delhi in 1983 and appeared in High Court of Delhi and tribunals, and his lordship has dealt with diverse matters such as constitutional law, direct taxes, arbitration, commercial matter, company law, land law, environment, pollution law, and medical negligence. His lordship also argued criminal cases in Delhi High Court as an additional public prosecutor and had a long tenure as a senior standing counsel for Income Tax Department in Delhi High Court. His lordship was appointed as standing counsel in the year 2004 for civil for the National Capital Territory of Delhi. His lordship was elevated as judge of Delhi High Court in 2005, and as High Court judge, his lordship was actively associated and involved with Delhi Judicial Academy, Delhi International Arbitration Center, and District Court Mediation Center. And I have to share one thing. When I was judge in charge of Delhi Mediation Center, the Justice Sanjeev Khanna was heading the Mediation Monitoring Committee, and under his lordship guidance, the mediation has gained a different direction and magnitude and has become a very innovative tool for dispute resolution. His lordship was elevated as Judge of Supreme Court of India on 18th of January 2019. Sir, we welcome you, sir. Honorable Mr. Justice A.K. Sikri is an eminent jurist and Elevated as Judge of Supreme Court of India on 12th of April 2013, His Lordship served as Chief Justice of Punjab and Haryana High Court and Judge of Delhi High Court. Presently, he is an international judge at the Singapore International Commercial Court and also the chairperson of the News Broadcasting Standard Authority. I am very delighted and glad to share His Lordship had excellent academic career and was enrolled as an advocate in 1977 with Bar Council of Delhi and has dealt with all type of cases with specialization in constitutional law, labor service matter, arbitration matter. He was designated as senior advocate by Delhi High Court on 30th of September 1997 and was chosen as one of the 50 most influential persons in the intellectual property in the world by Managing Intellectual Property Association, MIPA, for the year 2007. His Lordship was conferred Doctorate of Law by Dr. Ram Manohar Lohia, National Law University, Lucknow in November 2013. His Lordship is having keen interest in ADR, including mediation, and he is the champion of implementation of mediation in this country. His Lordship was member of Journal and Academic Council of National Judicial Academy, Patron-in-Chief of Delhi Judicial Academy, and Vice Chancellor of National Law School. The list is very long, sir. We welcome you, sir, in this session and in this conference, sir. Thank you, sir.
Well, I have a very long profile of Mr. Anil Xavier, and I thought you heard Hindi and Sanskrit. Let me add a little Punjabi tadka for this. That ਕਹਿੰਦੇ ਆ ਨਾ ਕਿ ਤੁਸੀਂ ਲਾਹੌਰ ਨਹੀਂ ਵੇਖਿਆ ਤੇ ਜੰਮੇ ਨਹੀਂ. And if you don't know about Mr. Anil Xavier, then you don't know anything about mediation.
Good one.
Mr. Anil Xavier is the chairman of Asia Pacific Center for Arbitration and Mediation and the president of Indian Institute of Arbitration and Mediation, IAM. Mr. Xavier is a lawyer since 1991 and practices mostly on corporate, commercial, contractual, company and contractual constitutional matters. Mr. Xavier is an international accredited negotiator and mediator of ADR Chambers UK, affiliated with Civil Mediation Council UK. He was designated as a senior fellow of the Dispute Resolution Institute of the Hamlin University School of Law, USA. He was nominated as chair of the International Accreditation Committee of Asian Mediation Association, AMA, for making standards for training and accreditation of mediators among member countries. He is the first IMI certified mediator from India and also an APCAM International Certified Arbitrator and APCAM International Certified Mediator. It is also important to mention that he is empaneled as an international accredited mediator of the Singapore International Mediation Center and IMI. We have had the Chief Justice of Singapore here. And now the list is very long, as was said. Welcome, Mr. Anil Xavier.
To start with the session, so my first question is to Justice Sanjeev Khanna. Sir, as we know, the Section 89 was incorporated in Code of Civil Procedure in the year 2002 and was made applicable from 1st of July 2002. Before that, mediation was not used in any statute in India. With the reintroduction of Section 89, the court annex mediation was formally introduced in the judicial process. So my question is that whether when we talk about the justice in the present context, whether the court annex mediation would be able to provide timely qualitative justice to the citizen, whether it would be a new tool for providing justice.
It is not a rehearsed answer. Let me first make it clear. When in 2005, mediation in the contemporary or the modern form was introduced, there was a lot of resistance. I remember attending the session in the law faculty, Delhi. There was a lot of resistance. In fact, there were open threats of strike given by several lawyers that if you introduce, you're shying away from doing the adjudication work. So first and foremost, let's accept that the oldest, perhaps the first method of conflict resolution was something quite similar to settlement and conciliation. but the modern concept is quite different. So the first issue which came up was how do we make people aware of the modern concept of mediation? Then how do we not only make the people aware, you have to make the lawyers aware, you have to make the advocates on board. So that was the first issue. Then was how do we reach out to the public? And then only the mediation could take the first baby steps. And Justice Sikri is a part of it. He's one of our founding fathers of mediation in Delhi, and to that extent, probably the founding father of mediation in India. But it has been on long journey since then. I have seen the figures. I got some figures, all India figures, with regard to the mediation and success or non-success of mediation. And I was pleasantly surprised that several states are doing fairly well as far as reference is concerned. Contrary to the popular perceptions we have, the largest number of reference to mediations is in Madhya Pradesh, followed by Maharashtra, followed by Gujarat and other states. And there are several states who are doing fairly well. There are issues which have come up. We have about 9 enactments now specifically referring to mediation. But unfortunately, in spite of Section 12A, the success rate of mediation, pre-institution in mediation has been rather low. One goes at the figure, hardly about 100 odd matters have been settled in last year. Only good thing about it is that every year it has been increasing. It has been going up. But the figures are very, very low. The other issue which is coming up, because we're looking at the roadmap for the future, is do we have sufficient number of trained mediators? That is again a big problem, which is, I feel, is staring at us, and unfortunately we are not able to specifically deal with it. Total number of trained mediators is 11,802. Out of which judicial officers constitute about 3,800 or almost 35%. Advocate mediators is 7,529. Expert mediators is 363. But as far as social workers is concerned, because we have to bring them on board, we have to bring on the public-spirited people on board. The total number of trained mediators as social workers is concerned is 103. And out of these 103, about 81 are from the state of Madhya Pradesh. So virtually we don't have any social workers or people from the industry or from the business or from other backgrounds as trained mediators. How do we bring them on board? Now this is a very difficult situation because one hand we require the cooperation of the lawyers and for acceptance of mediation. At the same time, we have to bring these people on board. So that's an issue. Again, the other problem which is coming up is with regard to the trainers we have, the number of trainer mediators we have. There are 115 if I include potential trainer mediators. So that again is an issue. Delhi has 34, Tamil Nadu has 14. But many of the states don't even have mediator trainers. So how do we go about it? It's fine that we have these 9 enactments which we have, in which we have this, which specifically provide for mediation, statutory mediations. But until unless we have trained mediators, how do we go about it? How do we make the people aware? How do we get that credibility and acceptance of mediation as a truly effective alternative to court adjudication? That's an issue which has to be answered by all of us. I'm not being pessimistic. There is a problem. But one way to look at the problem is to say, what can I do? I can't do anything. The other way to look at it is being optimistic and say, what can I do in the positive sense? I do everything to ensure that the problem is solved.
Sir, if you want to improve the court annex mediation, so we need to increase the number of cases referred for mediation, number of trained mediators, and the infrastructure and the mediation center as well, if you want to make this Section 89 more workable and practical for court annex mediation?
I think we require specific data. Unfortunately, the data available on the websites don't refer to the total number of new cases filed and percentage, which is then referred to mediation. When I was in charge, we had prescribed a pro forma, which was to be attached to each case, each new suit. So the judge will write whether he has talked to the parties at each stage of the litigation. Initial stage, the filing of written statement, framing of issues, evidence, beginning of evidence after plaintiff's evidence is over, and then after defendant's evidence is over, before the arguments start, and afterwards, whether he's explained to them whether the matter should be referred to mediation. The judge had to write and tick up the box whether he has spoken to the parties and whether, and thereupon what his opinion was, whether the parties are ready or not. I don't know whether it's been followed up. But what is apparent is that the figures are fairly impressive in Delhi. Other places also figures are impressive, but there are pockets where the figures are very, very low. Either reference is not there, or even if reference is there, they must simply, most of the cases are non-starters. They were not taken up. So these are issues, these have to be dealt with specifically, city, state specific. So the question is awareness, acceptability and credibility. And then only we'll have a truly effective alternative dispute resolution system. The awareness has to be not only that there is some system available, but awareness as to the rights of the parties and what is mediation. They don't give up any rights. The right to get into or sign a mediation settlement is with the parties themselves. So you are no loser. There's no loser in this when you go to a mediation. You can only settle and get out of litigation. So you don't lose anything. Until unless you explain that to the parties, even in the Supreme Court, sometimes when the parties appear, we make it clear. So they're always apprehensive. Will we be forced to enter into something? What happens to the confidentiality? What happens to my rights? Is the judge shying away from deciding my legal rights? So we have to explain to the parties that when you go for mediation, you're not losing on your legal rights. You are just trying to explore possibility if something is acceptable to you and can resolve the litigation.
Lord, Justice Khanna just now, this question to Justice Sikri. Justice Khanna flagged issues of settlement rates, training of mediators. We have heard Justice Sundaresh Menon and Justice Kaul talking about mediation percolating to grassroots level. Justice Menon also told us that initially they took up community disputes when the whole process took off. Then we've had discussion whether the awareness should reach the level of Mofusils and Munsif's courts. Now, in that light, instead of getting bogged down, because there was another debate about whether lawyers should be paid, whether the client should be made to pay. So let's not get into that. On the question of awareness, Justice Sikri, in various countries like USA, Australia, New Zealand, mediation centers are either funded by the state or being run by private parties, including NGOs. Lord Luscious will know that even there is reference to CSR under the Companies Act. Now, whether in India it would be appropriate for the central government or state governments to set up fully funded community mediation centers so that mediation can percolate to grassroots level for resolution of community disputes?
A very interesting question. I think since yesterday we have been debating and various facets around this question have been discussed in various panel discussions. Before answering it and going little backward and where Justice Sanjeev Khanna left, or rather what he said, something out of that, and giving my perception and then specifically coming to, because in order to connect the dots, we have to see, Justice Khanna has mentioned about certain challenges which we face even today, apart from awareness, resources, etc., and trained mediators, because that would have impact on the question which we have asked. And of course, it was in the context of court annex mediation. But one thing which we have to, and the silver lining in the whole process, which we have to look into is Mr. Khanna, Justice Khanna himself mentioned about how there was an adverse reaction from the bar in the beginning when it comes to mediation, and they were not happy. If you remember, and Justice Jain would be knowing better, he must have seen it when the pilot project was started in Delhi, and for first time, and the Chief Justice of India going to inaugurate that, and the advocates had ransacked the mediation center. So from that stage, in 2005 or 6, maybe sometime in 6, in 2023, in 16, 17 years' time, how much we have achieved, that has to be cherished and that has to be lauded. Because number one, insofar as attitude towards mediation is concerned, it's totally changed as far as lawyers are concerned. Lawyers now welcome it. They know that it is the ADR, which was perceived as alarming drop in revenue. ADR, it is no more. Rather, it is another dimension of practice which may generate more income. And another thing which I always say, that I am thankful to Salem Bar Association, which filed the case challenging the virus of Section 89. Because normally what happens in India, there are many laws which are passed which remain on statute book only without any implementation. But the effect of that was, while pronouncing the judgment and dismissing the petition, Supreme Court did not rest at that. They rather constituted the committee, which will chaired by Justice Rao, who was the chairman of the this law commission at that time. That rules would be made. That model rules were made. Then they directed all the high courts to make the rule on that basis, and rest is a history. So therefore, and the Supreme Court came forward that we have to implement it, and so MCPC was set up and all that. So that is one positive thing. Second, we know when we started, if I'm giving the example of Delhi, we started in Delhi when in Delhi High Court, the mediation center was set up, and we came together. You people were involved, Sadhna, Amarjeet, and all among us, judges who were there. We had no clue because there was not a single mediator, trained mediator in Delhi. And we took the help of persons like Shriram Panchu and others, and who would come to Delhi, give training. And today the position is that most of these, including from the judiciary who got the training at that time, and persons like you who go all over India and sometime abroad also to give trainings. So this is the remarkable transformation and a positive aspect which has to be looked into. And today, even if we go by the figures, Justice Khanna, which you have mentioned, so if we can have this kind of, figures that at least there are 13,000 trained mediators and trainers, etc., 300 or more, but then we can always expect that these figures would go, and we can meet the challenges. So that is the positive aspect which is to be seen. And now, once we have this, and we know as far as Section 89 is concerned, or Court Annexed Mediation is concerned, government gave good support to this, because in the 13th Finance Commission, much budget was allocated for the establishment of mediation centers throughout the country. And it was, of course, the money was given to the high courts, specifically earmarked for this purpose, which was to be spent through the legal aid, the state legal services authorities, high courts and then state legal services authority. But then what it did, it had the effect, and today at least there are many chief justices who are sitting here, they would be knowing better. In most of the courts, now there are mediation centers which are set up. So therefore, government here, now specifically coming to this thing, that government support is needed. There's no doubt about it. And what is happening is that from this, in last 16, 17 years, what we have learned, and we have discussed that also in last 2 days, we have been discussing, we have learned about mediation, that initially it was perceived when advocates did not know what mediation is. Parties would, in any case, won't know. When the judge refers the matter for mediation and to a particular advocate, so if you go to Mr. Shriram Panchu, he'll think that my case, instead of just deciding himself, now it will be decided by him. So didn't know what the mediation process is. So that awareness had to be there. From that stage, where now this is becoming successful, and now in many statutes also, the government has said about Section 12A, which was mentioned by under the Commercial Court Act of pre-litigation mediation. So therefore, private mediation has to be there. Now, as I said, two things which are important is initially it was still thought of, even if the mediation is to be done when the people did not know about the process. But it is just to, and we always discuss that in the beginning, in our mediation training programs also, that look, it is to ease the burden of the court. As if, courts are burdened, no doubt, they are overburdened, but what is realized over a period of time? And the second aspect, which is, I would say, is more important aspect, that it is the better form of access to justice. The way dispute can be resolved in mediation, and that in many, many circumstances, some of the success stories which were narrated also, and I must be having at least more than a dozen such stories, where the litigation, or I will say adjudication, whether through litigation in the court or arbitration, would not have achieved such a result which the mediation could. So I feel that in many circumstances, it is the real access to justice, the manner in which dispute resolution is provided and the solution is provided, and out-of-box thinking which adjudication can never accomplish. So therefore, time has come, and what was said, that we have to have now private mediation, we have to have community mediation, so it should spread. It should not now be limited to Section 89. And the manner in which the government held, as far as setting up the center, giving money when it comes to court mediation, and I think that it is necessary to have the mediation centers funded by the state, as you have mentioned, and we know in many countries like US, Australia, New Zealand, etc., this has been happening. And in Delhi also, Delhi government started this. We know, I think it was in 2009. I think Mr. M.L. Mehta,
Community-based mediation.
Yeah, Justice who became judge of the High Court later, and but he was law secretary at that time and started Delhi Dispute Resolution Society for community mediation. So therefore, government help is needed. Of course, I would say NGOs may also come forward, as it has happened. So here we can, and if you remember, Justice Menon in the morning saying, insofar as this landscape in Singapore, which it has developed, the 3 or 4 institutions which he named, that it's an interesting thing. It's not only SIMC, Singapore International Mediation Center, but SIME also. So there is an institute as well for studies, for training of mediation, etc. And there is there's some other institute also he mentioned.
CME.
Yes. So therefore, I think this kind of infrastructure or this kind of mediation, the way we have to culture which has to be developed, all these types of institutions are necessary. And particularly when we talk of private mediation, which is now which has to come, and the institution, it has to be institutionalized as well. So therefore, in this process, I would say, and one thing more I would add here, that look, what we have seen, I'm giving the example of arbitration. In arbitration, although India arbitration is there, it is prospering, it is, thriving, no doubt about it. But when it comes to international arbitrations, India is, even today we are struggling, it is not a problem because of the lack of institutions, and particularly lack of international institutions. So therefore, we need it. We need, and let us learn from that. Now we have decided, and the government has stepped in, law is also passed, and that institute is created. Let us see what is how much, and the chairman is appointed only a few months ago, or rather hardly 1 or 2 months ago. And therefore, what happens? But that learning from that lesson in mediation, we should start from beginning. And therefore, for this purpose, it is the government also has to come, private stakeholders also have to come, and your Madhyam is one such organization. In private, we can call it NGO, which is working really fine. I always think that our Delhi High Court, it is called Samadhan, and that is Madhyam. So this Samadhan is through Madhyam. So therefore, this collaboration is needed, and that would be my answer.
Can I just say one thing? I just got the figures because 2015-16, the total number of settled cases through mediation was 53,000. In 2017-18, it went up to 107,000. Even in 2018-19 and 19-20, it was 98,000 and 94,000 plus. Of course, then the COVID had a little, they pushed it back. Up till January 23, for the year 2022-23, it is 75,000 plus. So we should be crossing 1 lakh. So if one takes the cumulative number of cases right from 2005 till today, it's 7 lakh plus which have been settled through mediation, which is a fairly substantial number. I don't think anywhere in the world it's comparable. 1 lakh cases being settled by mediation in one financial year is a figure which we have to be very proud of. And given the numbers, look at the number of mediators we have.
Now, Mr. Javier, since you are having vast experience as mediator in private mediation, also you are attached and associated with large number of mediation institute. Section 89 talk about the court annex mediation. The Justice Khanna have said the figure his lordship has given. All these are pertaining to the court annex mediation after incorporation of Section 89. But since the morning, Justice Sandesh Menon, Justice Sanjay Kishan Kaul and other honorable speakers, they talk about the pre-litigation mediation also. So there is a demand, a demand from the all corner. It is felt necessary that the pre-litigation mediation be also introduced in the system. So my question to you for your valuable response is, should pre-litigation mediation be made mandatory in all types of dispute before they are filed in the court? And whether mandatory pre-litigation mediation is in consonance with the right to access to justice? What are your views on this pre-litigation mediation?
Thank you for the question. Before answering the question, let me thank Samadhan for inviting me for this wonderful conference. And coming to the question, of course, when the mediation law was made initially, and it was presented to the Parliament, pre-litigation mediation was made mandatory. And when it was referred to the Parliamentary Committee for studying the aspects and implications of the law, the Parliamentary Subcommittee had an opinion that it should not be made mandatory, in the sense that making it mandatory will actually delay the justice delivery, and it can create an additional tool in the hands of litigants to delay the process. That was the opinion that was given by the Parliamentary Committee. And of course, we all know that mediation is voluntary, it is collaborative, and it's also controlled. When the process and the outcome is voluntary, to make mediation or to attempt mediation mandatorily or compulsorily, maybe let us take it as a technical thing, maybe it will be against the spirit of mediation, because when it's a voluntary process, going for mediation also needs to be voluntary. And the main apprehension when it was made, and when of course in the drafting committee, when it was discussed, of course I was also in the drafting committee along with Mr. J.P. Singh, when the Supreme Court constituted a drafting committee. It was discussed elaborately, and it was felt that since mediation is not popular, we need to make it mandatory. And that is why at the very beginning in the law, we made it mandatory. But then, of course, when the standing committee commented on this, we also had a study on that, because after the standing committee was made, there was an expert committee constituted in which also I was made a member. We actually did the research on it, because one of the basic apprehensions when it was made mandatory was whether people will go for mediation when it is not made mandatory and it's only optional. And but actually speaking, see, we from the side of service providers or policymakers, we are thinking or we are anticipating the mindset of the litigants. And actually speaking, we were surprised to see many corporates, because see, since there was no mediation law, and there was only, when you talk about private mediation, the only act available was the Conciliation Act or the conciliation portion of the Arbitration Act. Many people were not familiar that whether the conciliation would work in the process of mediation. It was a different concept altogether. But once the mediation law is made, then the concept of mediation will become familiar. In fact, many major companies, and in fact some public sector undertakings, they have already altered their arbitration clause in the contracts and they have shifted it to mediation, anticipating that the mediation law is coming. And even they have made attempts to train their legal officers and their in-house counsels into mediation advocacy, so that they are equipped to handle their disputes after the mediation law is made. So anticipating a mediation law, if people can make alterations to incorporate mediation into their process, definitely I feel that once the mediation law is made, you don't actually may have to push them to mediation. They will actually accept mediation as a primary step. So even if you look at the Commercial Codes Act, only in matters which doesn't have an arbitration agreement, the court will compulsorily send you to mediation. If there is an arbitration act, naturally it will be governed under Section 8 of the Arbitration Act, and the parties will have to appear before to arbitration. So similarly, when there is a mediation agreement in place, because now after the standing committee has passed on the comments, in fact, we had a discussion, and in fact, Mr. Panju was also there. We actually thought of including a section similar to Section 8, where if there is a mediation agreement in a contract, then if a matter is brought before the court will have to refer the parties to mediation, because similar to Section 8 of the Arbitration Act. So that also we have recommended that in the law. And so considering these situations, I don't feel, because see, as you said, access to justice. See, access to justice, of course, it's a constitutional right. And preventing or prohibiting a party from accessing court because they are not resorting to mediation, which is a procedural thing, will be actually preventing the party access to justice. Because when a party can go to a court of law for his right, saying that if you don't go for mediation, which is a procedural step, you will be denied access. So even yesterday, Mr. Sundaresh Menon, Justice Sundaresh Menon, when he was discussing, he said in Singapore also, even though it was tried to make it mandatory, they did not make it mandatory. First, they gave it as an option. And once you give it as an option and more people start using it, definitely the benefits are obvious and people will go for mediation. So I don't think, and of course now the present recommendation given in the Act is not to make it mandatory, to make it optional. But of course it is up to the government to decide on that.
Mr. Xavier, you mean to say, being the mediation informal in nature, it should be left at the will of the parties either to go for mediation or to go for litigation. The pre-litigation mediation should not be made mandatory. Otherwise, it will be opposed to their constitutional right to access to justice.
So now, of course, when the law comes, we don't know, because now, as far as the law is, in the present state of affairs, the law says it is mandatory. So
you are not satisfied with you are not happy with Section 12A of the Commercial Codes Act.
Naturally, of course, it is now before the Supreme Court, because there were some conflicting judgments by different high courts. I think the Chennai High Court has said it is only directory, it is not mandatory, even though it says so. So there are conflicting judgments by different high courts whether Section 12A is mandatory or directory. But I personally feel that preventing a party from going to court just because he's not opting for mediation, which is a procedural aspect or a thing, maybe putting a hindrance to his access to justice. And it should be made as a a natural course of things where when the decision-making process is voluntary, the option to access mediation also should be voluntary. But it all depends on the culture.
If I may say so and interject only one sentence, it's I mean, it's a debatable issue. You are very right. Whether it should be mandatory when it's a, process which is consensual. There are some observation to this effect in the context of Section 89 under the arbitration. Then the court said, Supreme Court said, no. As far as mediation is different, as arbitration is concerned, you cannot send the parties unless the parties agree to that, because it has to be based on an agreement between the parties. But there's one good saying that you can take the horse to the water but can't force it. So taking the horse to the water is mandatory, which is our right, we can do. We can't force them to drink the water. So this can be perceived like this.
Yeah, in fact, the people who favor mandatory mediation always tell us a story. When children are playing in the mud, when they ask to take bath, they will not go. But if they are forcefully taken from the mud and put them into the tub, they will enjoy playing in the tub.
Okay.
So taking from the mud to the tub is the mandatory.
This is better example.
Question to you, Justice Khanna. This is in line with the theme of this conference. Your Lordships have given us some figures about the statistics which we've just seen. I remember reading Justice Ravindran's article some time back, where he said the pending litigation is so much in India, even if new matters are not filed, it will take nearly more than 100 years to settle all those.
Justice A.P. Shah said 300 years.
300 years. So therefore, litigation, lawyers should know litigation is going nowhere.
I read one study, it says 482 years. Sir.
That figure is not correct.
So now they say, in view of how mediation is being perceived, that it said that generally the future belongs to mediation. Now, looking at this particular aspect, what would your Lordship say would further steps be taken to strengthen the institution of mediation in India?
I think first and foremost is familiarizing people with what is actually and giving them information what exactly is mediation. A lot of time there's a gap between what we understand is the modern concept of mediation and what they perceive is the mediation when they look upon their family members or people in the trade and business. That can only happen in case we spread this information, we spread and make the people in the business and the trade aware about it. That, to some extent, can be done by us, but it has to be done at a much, much larger scale. It has to be done on a war footing. That is possible through media. It is possible through the courts. And of course, with the cooperation of the advocates. Without that, it's impossible because they are the ones. But we have to have an approach where we can bridge the gap between lack of information, lack of familiarity with what is the contemporary or modern concept of mediation.
Very interesting session which was there before lunch. It was discussed that why not spread the success stories of mediation, and the people will come to know about mediation and benefits of mediation more appropriately in that manner. Yeah, please continue.
That's exactly the benefit of mediation, because you're not a user in any case. You're just trying to resolve something without going to the court. I think all of us believe that none of the citizens feel that going to the court is the best thing to do. They'll avoid it at any cost. So take advantage of it and tell them that there is an alternative way which will give you the full benefit, what you want. And also tell them that, look, everything cannot be decided legally. Legal rights cannot, everything is not dependent upon legal rights. So much more than the legal rights. There are social effects, there are economic effects, there is consequence, time is value. Time value for money, everything is involved. So you have to spread that idea. Community mediation should be our goal. Should be our goal because we'll not only solve civil cases, we'll solve criminal cases also. We'll prevent criminal cases from coming to court. That has happened in Delhi. Madhya Pradesh, for example, has community mediation scheme, but other states have probably not initiated those. Coming with the, I'm sorry, I'm giving too many figures to you. In fact, coming to with regard to the pre-institutional mediation in Section 12, 20,000 cases were referred up till September 22. 19,500 were non-starters. So virtually it's not happened. Why it has not happened, I'm not going into it. But it's not happened. It's also another story. Why did it not happen? Why were there non-starters? Why were they non-starters? And most of the arbitration clauses today have mediation as a first step. How many cases are getting resolved? I don't know. The figures will not be available. But the other interesting figure is, as far as Delhi High Court the Delhi High Court Mediation Center is concerned, the statistics of pre-mediation, litigation, conciliation are much better. Almost in 1/3 matters, the settlement has taken place. So if it can happen in Delhi, out of 3,600, 1,027 settlements took place. Referred case. If it can happen in Delhi, why is it not happening? So there is some disconnect. We'll have to find out where is the problem and deal with that problem.
Sir, I remember when your lordship was in charge of the mediation monitoring committee for district courts. Under your guidance, we have taken various innovative steps to propagate mediation. And one of them is the settling of the mediation table at the facilitation center, so that at the first hand, the information regarding the benefit of mediation can be given. Then the display of placard also, and mediation performa, and annexing, and then the mediation pamphlets were annexed with the summons when the summons were issued by the court at first instance. So under your guidance, we have taken various steps to promote mediation at threshold levels.
Because those non-starters, I mean, I was part of certain matters where either it's the government who's not willing to participate, or there are large, even commercial houses or the business, for example, or big companies. For some reason, the lawyers' advice or whichever, they're not willing to go in for mediation, and they say, let the matter go for arbitration. So therefore, probably there is, as your lordship said, probably that has to sink in with the end user, that mediation is not saying that you go and settle, but explore the problems which are there, and maybe some minor issues can still get resolved. I've had an instance where out of 6 disputes, 5 were resolved. The 5th one was interpretation of the clause of the contract. They said, we'll refer this to a judge. 5 matters resolved. That interpretation was referred for arbitration to an honorable retired judge. So there are possibilities of this hybrid results happening, but people need to attempt.
I have done quite a few cases after arbitrator, mediation, arbitration, both, and these kinds of disputes. And let me tell you this another very interesting anecdote, and it happened in our Delhi High Court Mediation Center, where I think NDMC or some, I think it was NDMC, which was a party. It was a dispute relating to electricity bill, which was sent for mediation. The parties agreed. It was month of March, and the amount which the consumer agreed to pay, which NDMC's, the counsel and the representative came, they also agreed. They said that we have one problem. We want this entire money before 31st March. He said that I can't give it before 31st March because it may be 20-30 lakhs of rupees. I can give it only 3-4 installments. So what should be done? He said that without that, we are not accepting the settlement. NDMC said it. So this was the innovation of the mediator. He found a way out. And he said that, look, let us enter into the settlement. And as far as the question is concerned that how you can pay and we leave it to the judge, because it was matter set by the court. And the judge, of course, was briefed about it, where the matter was there. So when the parties left that, as you said, 6 out of 6, one aspect which they could not say. And the judge said that, okay, in my discretion, I am laying down these installments. It will be paid in these installments. So that is my order. And the matter got settled.
So my next question is to Justice A.K. Sikri. The very question of is a great importance, and we need some guidance from your lordship. Now, sir, since morning, what we have experienced and what we have deliberated, now the mediation is expanding in its application in India, and large number of potential mediators have been trained in concept and techniques of mediation. But different training center like MCPC and private mediation center or training institute, they are having their own standard of giving training to the potential mediators. So my question is to you, sir, is that what steps should be taken by the government to develop national uniform system of accreditation of mediator? And next point is that to establish suitable council to provide code of conduct and ethical principles to be followed by the mediator. Because tomorrow it would be a very big problem regarding the ethical principles to be followed by mediator and code of conduct, like we are having the Medical Council of India, State Medical Council, Bar Council of India, Bar Council of Delhi. So those who take up the issues when there is a violation of any ethical principle of code of conduct by the different professional. So we also need these kind of bodies or institute or which can take care of the ethical principles to be followed by mediators.
So Justice Jain, you have asked the question and you have given the answer also. Actually, if the answer lies in enacting Mediation Act. So if once we have all these other disciplines which you mentioned, whether it is medical profession or legal profession, etc., we have the acts which have the provisions of code of conduct or ethics which is followed. We have provision for taking disciplinary action as well if something wrong is committed by any such professional, whether it is medical council or it is bar council, so they are given these powers. And this same is under the Chartered Accountant Act also. Yes. So same thing now, once we are discussing and we are talking about mediation, and I really liked what Justice Sundesh Menon said in the morning, that time has come when we have recognized today it's not only an alternate, it is one of the systems of dispute resolution along with litigation and arbitration. So therefore, it depends upon the parties how they choose and when they choose. And many times, and when we are having this med-arb or med etc., that is in respect of arbitration and mediation. But Section 19 is litigation, arbitration, litigation. So therefore, in this scenario, when we want this kind of harmony or synthesis between the three now dispute resolution mechanism, we need to have Mediation Act as well, so that all these problems will also be taken care of, and there would be a better synergy between the three institutions and how to do or how to transit from one to the other or come back.
Two parts, Mr. Xavier. As you just now expressed, you're not very happy with the bill, the way it's moving and how, in fact, Justice Kaul said that, he's looking for the bill to become a legislation soon. So do you feel that the Arbitration and Conciliation Act itself could have been amended instead of having a standalone litigation? And secondly, what kind of improvements you see could be made in this legislation, which would also bring it in line with the Singapore Convention?
Okay. First, the first limb of the question regarding whether the Arbitration Conciliation Act could be changed to bring in the concept of mediation. Of course, the UNCITRAL, when it made the model rules on conciliation in 1980, the general concept all over the world was mediation and conciliation are interchangeable terms. But again, when the model rules on international conciliation was made in 2002, initially that instrument was made, but subsequently it was withdrawn because UNCITRAL working committees thought that the term mediation is more popular and it's more prevalent amongst the common people. So instead of using the word conciliation in different parts of the world and mediation in different parts of the world, they wanted to make it uniform in the sense that mediation should be the term that is used. So immediately they withdrew the international model rules on international conciliation and they made the model rule on international mediation. And subsequently, when the Singapore Convention came in, there also it was the enforcement of international mediation settlement agreements. So that is one thing. So if we want to change the law, we need to amend the Arbitration Conciliation Act into Arbitration Mediation Act. But secondly, the other thing is, as in the earlier question, just Sikriya answered, see, mediation, to make mediation a more standalone legislation, it's not just the process that matters. It also includes the code of conduct of mediators, the disciplinary process of mediators, many other incidental things have to be incorporated. So it's a laborious task to amend the Conciliation Act and to make it as a Mediation Act. So naturally, the Mediation Act has to be a standalone act, which incorporates everything in one place. And coming to the Mediation Act, whether it is comparable with the Singapore Convention, of course, when the drafting committee made the law, the enforcement of international settlement agreements was there. And when the government published the first draft, it was there. But to the shock of all of us, when it was presented in the parliament, the entire chapter was vanished. And we did not have any idea why this was vanished, because the objects of the act, see, first of all, the purpose of the act was to ratify the Singapore Convention. And secondly, when the draft was made, the chapter with respect to enforcement of international settlement agreement was there. But then when suddenly it was brought before the parliament and then the entire chapter was vanished, we were wondering what happened. And then, see, because I was also an observer member in the working committee 2 and 3 of the Institute, where this issue was discussed many often. Because, see, we said, in fact, Chief Justice Sundararaman also said, this is one instrument where 46 countries went and signed on the very first day when it was open for signature. At that time, I would confess, that most of the countries did not think about the consequences of signing it. Because we were all familiar, or more familiar with the New York Convention. And we thought, since New York Convention is enforcement of international awards, Singapore Convention is similar to that, and it is for enforcement of settlement agreements. But there was a drastic difference in ratification. Because under Article 10 of the New York Convention, every signatory state had an option to exclude certain countries. So if we are not happy with certain laws or certain procedures of a particular country, we can exclude it. So for example, right now we have 172 countries who have signed the New York Convention. But India has only acknowledged 49 countries by way of gazetization. So we only accept international arbitral awards from 49 countries and not from the 172 countries. But under Article 8 of the Singapore Convention, this provision is not available. So if you ratify the Singapore Convention, you have to take all the settlement agreements from all the 195 countries. It's not 55. Because right now we have only 55 countries who have signed it. But since mediation is not a citus-based or seat-based process like an arbitration, settlement agreements which are made anywhere in the universe will be eligible for enforcement if we ratify the Singapore Convention. So the apprehension of the government is not that unfounded. Because if you ratify it, we will have to enforce settlement agreements made in any part of the world in India. And the government is apprehensive because many countries we do not think that the law is that developed or their ethical standards are that good, or whether we would be taking in those settlement agreements and enforcing it in our country. So there is a huge, because even though the standing committee said that international settlement agreements have to be incorporated because otherwise the purpose is lost, but they also didn't have an answer. They said that there has to be a holistic study about the consequences of ratifying it. And that is what I feel that is the delay in coming up with the law. But of course, we need to understand that Singapore Convention is a treaty. And when, as a country, we have signed a treaty, we are obligated to make a law to enforce it. Because otherwise, if we make a law without ratifying a treaty that we have signed, we'll be considered by the international community as a backward country. Because we are not, complying with the treaty. So we need to have a portion which will contain the enforcement of international settlement agreements. And we need to make sure that we make certain provisions which can, not by excluding countries, but in some other manner, we can prevent enforcement of settlement agreements which are not according to us into that standards. So it's a bit of a dicey situation because we cannot exclude any country because the Article 8 is very clear. We can only say that these type of disputes are not possible for settlement, but we cannot exclude any country from from this implementation. So that's the problem.
But looking at what is being said and these issues being raised, when we went to America, we were told your Section 89 has worked very well in spite of what the Supreme Court said about drafting. Don't have a standalone legislation, it will make it more rigid.
Okay.
And what the professor said, that the American mediators are actually settlers of dispute. And the Indians who give so much of importance to relationship are actually healers of dispute. So you don't have to go by a law. Continue with your mediation the manner you choose.
No, but this
It's one
situation-
way of looking at it. In last 16, 17 years, we have come this long way without any mediation act. But the position has changed after the signing of Singapore Convention.
Yes.
No,
No, but the situation is not
our
just confined to
obligation
India.
is concerned, yeah.
In
And now advent of private or pre-litigation mediation.
And it's actually a form of meditation. Now that when we realize, like earlier we mistook it as meditation, but
Yeah.
today I feel like when you are doing real mediation, actually it's a form of meditation. Sir?
In fact, I have one more line to that, because even though 55 countries have signed it, we have only 11 countries who have ratified it. Because this issue is happening and this discussion is happening in many countries. It's not just confined to India, because the ramifications of ratifying it was not considered at the time of signing. Because people
I
did
think,
not.
if I am not wrong, Mr. Xavier, you would be knowing better. It was last minute push given
last
to
minute push,
I remember that.
Yeah, it was-
and
it was a 2-3 days back.
our High Commissioner in Singapore was asked, you go there and sign it.
Sir, one thing is more regarding this question. If the mediation bill is actually converted into a proper legislation, what I anticipate, there will be a 20-20 match between Mediation Act and the Arbitration and Conciliation Act also.
No, as per the new bill, once the bill is passed, then the conciliation part of the Arbitration Act will be repealed. So there will not be conflicting
Let's see.
provisions.
So now, sir, one or two few general questions quickly. So, sir, for all the panelists, sir, India is a country of diversity. The multiple societies are prevailing. Where my question is that, keeping in view the diversity in socio-economic conditions prevailing in India, whether mediation would be effective in multicultural disputes.
Multicultural disputes.
Multicultural disputes, sir.
Why not? I think a person like Mr. Xavier or Shriram Panchu or Brij Bihari would be, since they are working on the field, can answer this better. But from my little understanding, on the one hand, when we talk of community mediation,
Community mediation.
so they're persons in a particular community. It's not necessary that they belong to same culture, same caste, same religion. There may be of different culture, different religions also. Whenever there are disputes where the parties are multi-parties spread over different areas, etc., they may be of different culture, etc. The best example was, although it did not succeed, but I feel that this mediation, that Ram Janmabhoomi
Ram
case,
Janmabhoomi.
which was referred, but the positive effect of that, because we say many times, even if the mediation has not succeeded, it may have other positive ramifications. That the attitude in the court when the matter was argued, the parties had softened their attitude. So which was, I feel, I've never interacted on this with Shriram Panchu, but I feel that this was great mileage, which was, at least even when they could not settle, and it was a matter like this, even when the court wanted it to be settled, but we thought that ultimately the parties would say that no, that the Supreme Court settled. But the kind of environment which you created, and because of that, and particularly the parties which coming, and the judgment was easily accepted by all the communities. That is the result of this mediation discussion which take place. And it is again, two different culture or two different religions are involved in that.
So even sir, within the state, there is a diverse cultures they are prevailing, and they are having the interstate dispute with each other, particularly
Because
in the
another thing which I may say is, we are in mediation. We deal with human relations. And as far as, and rather humanity, if I may say so. And that is same in all cultures and everywhere. So once the mediator is trained in that particular field, I think he can always bring them together at the same table, even if they belong to different cultures. But yes, it may be a matter of challenge for the mediator in comparison with other types of cases, but not an impossibility.
So I think
one of the situations which we are faced with and multiplying the product, whether through mediation, arbitration, or litigation, of course, every stream is delivering us a result. But at the same time, there is a conflict of remedial mechanism. The conflict of remedial mechanism is also posing us a challenge.
It's not conflict, I would say. It's a different types of remedies which have their different milieu, or different environment. We can't say conflict. Yes, adjudicatory process has to be different from mediation process. So, but then they are not conflicting with each other. Yes.
Now, our civilization by and large has to be the criminal mechanism. Here are certain areas wherein the parties have an agreement. Suppose it is an agreement of some service. Industries manufacture products, products are sold in the market. Then there are service contracts, supplemental contracts. Somewhere they postulate arbitration clauses also. One of the situations which I was faced with respect to the service contract, there was an arbitration clause. Now, because of some conflict, arbitral notice was issued by a foreign company to an Indian company who had purchased some product.
Here, conflict you are saying in the sense of a dispute.
Because now the arbitration clause was there. The foreign company invoked the arbitration clause. The Indian company thought that not only the quality of the product was substandard, but the service which the company rendered under that separate agreement was also deficient. They took shelter of the penal laws. They registered an FIR under section 406 and 420, and the courts proceeded. Now it was a monetary claim, was the arbitral notice was for 10 lakhs and odd. But the foreign company, in order to defend the criminal case in India, had to spend double and triple the amount what they had claimed through a arbitral notice. Now the arbitration clause is there. High Court permits investigation, gives
We understand. What is the point you want to
Now
make?
the
Please
point is,
come to that.
Point is, there the civil dispute postulates an arbitral clause. Criminal proceedings are on the other side going on. Now the matter comes before a high court. The high court sees that these criminal proceedings are unwarranted or ill-intentioned. Now the high court somehow wants to evolve mediation. Will this arbitral clause come in the way of high court?
No, how? Rather, I was going to say, in a situation like this, there are many. Now, Supreme Court also in Gyanchand judgment has said that in criminal cases also there should be mediation.
Mediation.
And we know, and you have rather given that example, and by giving this example, you have supported the proposition that in certain cases, even of criminal nature so-called, in inverted commas, because they have all the ramifications or the attributes of civil disputes, which are thanks to ingenuity of some lawyers, that to put pressure on the other side, or maybe sometimes this may be a failure of civil system in the sense that, okay, civil case may go on for 10 years, so let us convert it into cheating, etc., and file that case. As it happens in family disputes also, matrimonial, immediately 498A.
498.
So therefore, because of these reasons, it's not when you said conflict, It is not conflict. Because of these reasons, mediation becomes more important in such cases. So that rather you are giving justification to mediation in such cases.
No, in mediation, we immediately put on hold all other remedies
Yes.
available. Can this legislation envisage a clause that wherever the parties resort to mediation, all other remedies will come to a halt?
No, that you are saying that in the Mediation Act there may be a provision taking care of this situation as well. That's a different aspect altogether.
Lord, I think till the new act comes into being, let's live with the present legislations.
Yes.
And this discussion can go on. And I'm sure Justice Sikri has to.
Would you permit me to add, with the permission, permit me to add to what Mr. Anil Xavier was saying on that 12 capital A of Commercial Courts Act, pre-institution mediation, as to whether it is mandatory or directory. It was being mentioned. It has traveled to Supreme Court. No doubt different high courts took different views. It did travel to Supreme Court. But the point is, it is no more res integra.
Supreme Court
It has
is
been settled by Supreme Court and party law automation.
Yes.
2022 10 SEC page 1 is the citation.
Wow.
Paragraph is 113.1. Date of the judgment.
They have said
Date of
it
the
is
judgment is
prospective.
17/8/2022. I can read out paragraph 113.1.
Thank you. Yeah, what do you want to say?
Sir, according to Order 23, Rule 3 of Code of Civil Procedure,
I think it's not on. You be closer to mine.
sorry. Sir, according to Order 23, Rule 3 of Code of Civil Procedure, if parties are arrived at compromise, but court comes to the conclusion that this compromise is not lawful, court can refuse to accept that compromise. The question is, sir, that when matter is referred to the center and where the parties arrived at compromise before the mediator, and mediator has no power to pass any order, mediator is just required to refer the matter to the court. Now parties have arrived at compromise before the mediator, but court comes to the conclusion that no, this compromise is not lawful. Whether it is possible for the court to
Yes,
refuse that or
definitely.
not.
If the court comes to the conclusion the agreement is not
Then-
lawful,
then parties
law,
will be-
not lawful means contrary to some law.
Yes, contrary
then
to
court
some
will
law.
refuse to pass the decree.
Yes. Then what would be the purpose for referring the matter to the mediator?
and
Sir?
then-
Because mediator has no right to
No,
examine
no.
whether it is lawful or not.
Purpose was to come to a settlement which is legally valid settlement.
Yes, exactly, sir. That
So
is the reason why I
the
am asking.
settlement which is entered into if is not legal,
Legal.
then it is not enforceable also.
But,
so why there should be a decree in terms of that settlement?
But mediator has no right to examine these things, sir. Mediator has no right
No,
to
no,
examine.
no.
He has
Mediators,
just to
no. Why?
accept,
That most of the
note
time
down the
these mediators are lawyers. They know it. And in mediation training, this aspect is specifically gone into ethical aspects and enforceability aspect. As I have, attended mediation trainings, there are sessions on this.
So mediators are also required to be acquainted with this
If
before
we-
recording
and
the
question is
settlement between the
ethical
parties.
question if the parties agree.
Yes.
But mediator finds that the settlement which they are arriving at
Yes.
is not a fair settlement.
Yes, yes.
How far mediator can interfere, etc. So these are some of the ethical issues
Part of the
which
training.
arise. Yes.
In AFCON judgment, sir, this position was clear. As and when the settlement is received by the court, the first duty of the court is to examine the settlement.
Correct.
Ki
That
whether
is
it
what I
can be
said.
enforced or
Yes,
not.
yes.
It is the duty cast on the court also.
What is the use of passing the decree which is legally unenforceable?
Even today, my lord, we have a committee of mediators who go into this before a settlement is sent to the court. I think we need to thank the panelists for.
Sir, we extend our thanks to all the honorable panelists for wonderful discussion on various aspects related to the mediation. And sir, the guidance and the words of wisdom given by all our honorable panelists will enrich the knowledge of the mediators, those who are the part of this conference and others also. Sir, I extend my heartiest thanks to all of you and all the participants. Thank you very much.
Thank you very much, sir. We are grateful to all of you. With this, we conclude the fourth and last session of this national conference, and we will move on to the concluding session, valedictory session. But right now, we extend our gratitude to Honorable Mr. Justice Sanjeev Khanna, Judge, Supreme Court of India, Honorable Mr. Justice A.K. Sikri, former Judge, Supreme Court of India, and Mr. Anil Xavier, Chairman, Asia Pacific Center for Arbitration and Mediation. As panelists, they have given insight about the mediation law and different aspects of this procedure and the program. We are thankful to the moderators of this session, Honorable Mr. Justice Sudhir Kumar Jain, Judge, Delhi High Court and Member Overseeing Committee, Samadhan, and Senior Advocate J.P. Singh Saab. Thank you very much, sir. We are grateful to all of you. Ladies and gentlemen, in a short while from now, we will have the valedictory session. Please stay back, remain seated. We will take 5 to 7 minutes only to get ready for this for the valedictory session of this national conference.
ये मैं कर लेता हूँ